Om, 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 Om Sahana Vavatu, Sahano Bhunaktu, Sahaviryam Karvavahe, Tejasvinavadhitamastu, Ma Vitvishavahe. Om Shanti Shanti Shanti.
Namaskar and a very good afternoon to all of you. It's a great pleasure to welcome you all to today's Vimarsh talk by Shri Vikramjit Banerjee, Additional Solicitor General, Government of India. He'll be speaking on lawfare as a tool in international relations. Shri Banerjee is a counsel in the Supreme Court of India since 2007 and also practiced in the High Court at Calcutta. He has been the Additional Solicitor General of India since 2018. He was the Advocate General in the state of Nagaland. Shri Banerjee has taught at the Indian Institute of Management, Calcutta, University of Calcutta, and some other places. He was awarded the Chevening Scholarship from 1999 to 2000 by the British Foreign and Commonwealth Office for doing an LLM at the University of Leicester. He has authored articles and books on a variety of subjects and attended international seminars and conferences. His research interests include constitutional law, law and culture, law and religion, law and development. Friends, we usually associate warfare with the use of military force. The fact, however, is that today's wars are fought in multiple domains. Wars do not start with the firing of a bullet, nor do they end with a ceasefire. Information warfare is a fact of life and includes several dimensions, of which media is one, but equally important includes the legal domain. According to the Cambridge Dictionary, lawfare is defined as the use of legal action to cause problems for an opponent. Lawfare has become a key aspect of modern war. So it is in this context that we are holding today's talk. How is lawfare being used today as a weapon by state actors as well as non-state actors? And there are numerous examples if you look around. And take the recent case of India's decision to put the Indus Water Treaty between India and Pakistan in quote-unquote abeyance. India took this action on the grounds that terrorism and water cannot flow together. They cannot go hand in hand. So it was a very political decision, and it's flowing out of long history of India-Pakistan conflict. Pakistan has strongly contested India's action and is now trying to convince the international community that India has no right to do so. It is to keep the treaty in abeyance. There is nothing like abeyance that is provided in the treaty. And India's action to stop the flow of water to Pakistan is a breach of international law. And it will deprive people downstream of water, etc. So they're trying to sell this narrative. The dispute resolution mechanism provided in the Indus Water Treaty has also become a highly contentious issue. The appointment of a neutral expert and the court of arbitration, the two mechanisms which are provided in the IWT, the appointment of these two mechanisms on the same issue at the same time by the World Bank has been strongly objected to by India. And in fact, I think recently the Court of Arbitration has come out with their, ruling also, in which they have dismissed India's contention. Although, of course, India did not participate in those meetings. The ruling goes against India. So this is just one example which shows that India-Pakistan conflict is now spilling over to the legal domain. And this is not the end of it. I think Pakistan is going to use it in various ways, twist it. A lot of non-state actors will also take it. A lot of countries also take it. So we need to have a proper narrative on this. Incidentally, this is not the first time that India and Pakistan have taken recourse to legal alternatives. A court of arbitration had settled the Kutch boundary dispute between the two countries. I think it was in 1968. India had also approached the International Court of Justice to challenge Pakistan's death sentence against Kulbhushan Jadhav, an Indian national who has been accused of spying by Pakistan. States go to the International Court of Justice routinely, taking their disputes against other states and to other such fora. For instance, Ukraine has taken Russia to the ICJ for alleged war crimes in the ongoing war between the two countries. It has also filed multiple cases against in the European Court of Human Rights against Russia. The Philippines initiated an arbitration proceeding against China at the Permanent Court of Arbitration in The Hague, challenging China's 9-dash line, which justified China's claim over most of South China Sea. The PCA in 2016 ruling favored the Philippines, but China ignored the PCA ruling entirely and went ahead to occupy the disputed islands. South Africa has also taken Israel to the ICJ for committing genocide in Gaza. I think Gambia has also taken Myanmar to the ICJ for genocide of the Rohingyas. So there are many such examples, countless examples, where the states are using legal conventions and legal platforms to put pressure on the adversaries by tarnishing their image and even initiating sanctions. Most such cases are driven by political agendas, and getting the adversaries involved in legal proceedings this way, this is very time consuming, distract from the main issues, and it's a field day for the lawyers and so many other people. And it's not just the states, the non-state actors, the big NGOs, people, they are also using so many conventions and provisions, whether it's human rights or even in the field of environment and so on. So they're using these methods. And now with the emergence of new technologies like the artificial intelligence, space, cyber, internet, machine learning, synthetic biology, drones, and so many others, the technology, the law is not keeping pace with the technology. So in the legal domain, there's a lot of ambiguity. Many times the conventions are not there. And anyway, to get an international convention today, and Ashok knows it very well, to have an international, to build a consensus on international convention is next to impossible. You will not have international conventions anymore. And yet, I think the field of international law is becoming so complex and so confused that people are taking advantage. The legal development cannot keep pace with the emergence of technologies. And if you look at the Chinese understanding of warfare, lawfare is one of the information warfare. Lawfare is a very important part of information warfare. And likewise, other countries have also come up with some concepts of lawfare. Now, in our country, since we do not have a national security doctrine, so we fight as we go along. That kind of a thing. There doesn't seem to be any strategy. Whereas what Pahalgam showed us before and after, it's really in the domain of information warfare, of which lawfare is important. We ought to be making major, huge efforts. Now, our distinguished speaker will deal with these issues. But one thing that worries me a lot is what is the status of the study of international law in India? Who is studying international law? I remember when there was the Baglihar dispute was happening At that time, we were looking, I think some Shankar Das, some famous law. We had to put together one team quickly, and they started studying the Indus water treaty. Bhai, isme ye hai. Nobody understood because there was no problem. Nobody thought that Indus water treaty will lead us to this. But the Pakistanis were making, preparations and so on. So what is neutral expert? What is court of arbitration? How do we go about doing it? And we had some people, hurriedly they put together something and we made out some kind of a case. Kulbhushan Jadhav, we had to, I think, kaun hai wo aapki famous lawyer? Huh? Harish Salve. He fought it, but there's no thinking. And even today, maritime law, space law, cyber law, AI, now AI is a big thing. Who is doing this thinking? So we read something here, something there, but lawfare as a concept of information warfare, I think that is what we wanted to focus on this today. And perhaps the short point which I want to make is that we must spend a lot of resources in studying international law in all its dimensions. We should have thousands of people studying international law because everything is international today. From trade to terrorism, everything is international law. But I do not know. He will tell us. I don't know much about it. Whether in Supreme Court we have had international law, maybe a few cases might be there. I remember that Italian ship when he came. There was some, but that is different from studying international law and making teams of people, lawyers, and specialists who can deal it with. Trump is playing havoc with the whole world on the trade, etc. But how much do we? WTO is dead. So what's happening in the trade? So similarly, cyber, outer space. Outer space now, the whole world is going to outer space. Exploitation of resources in outer space is going to become a reality. The Chinese have already, they're sending probes. They are going to send probes to asteroids, and they are even planning to Mars and even to Jupiter now. They'll go pick up the samples, bring them back here. Now, is this all legal? Of course, there is this outer space treaty, but that is too, just a framework kind of a thing. Within that, space law is a one big gaping hole that we have today, and the whole world is now going to the outer space, and we are all sleeping. We do not have a proper institute to study the space law. Whereas in Canada, in Montreal, I remember there's a big, massive institute which has been studying space law for ages, and they're the ones who are setting agendas. So this is some of the angst that I thought it just come out looking at you, because it's very rarely that we meet a law officer from the Supreme Court. But I thought let us unburden ourselves on him and give him this opportunity to talk about law and as a tool in international relations.
Very much. I think I'm going to make a presentation, so it's easier for me. There's a screen here, so I'll read from here. So I'll, for the want of a better word, I'll sit and make my presentation. It's a pleasure and honor to be present at this very august institution. And I know what is the prestige of being asked to present a Vimarsh. So I'm thankful and very, very grateful to for giving me this opportunity. The concept of lawfare, as we are going to discuss, and that's my presentation, I think requires much intensive thought. It requires because that is the present demand of the ages. And whether we like it or not, we live in the age of what is called total warfare. And total warfare also means the use of lawfare as a tool for forcing the opponent to doing what you want them to do. That's the object of war. That's the object of diplomacy. And that is also the object of lawfare. That being said, I think we'll move to the first slide. What is lawfare? There is lawfare. There is a lot of discussion in American law, and I'll run through because it's quite an extensive. I think there are 30 slides, so I'll just rush through the presentation. Lawfare, the Americans define it, and there is a substantial amount of literature on this now, which says the strategic use of law as a substitute for traditional military means to achieve an operational objective. It was coined by Major General Charles Dunlap in a very, very famous 2001 article on lawfare, which basically defines lawfare. There are subsequently a lot of other literature. The crucial difference now and from then is, if you see the definition, which says the strategic use of law as a substitute for traditional military means to achieve an operational objective. The new sort of definition puts in to destroy the other person's legitimacy, using legitimacy as a tool to force the person to. So you delegitimize the person's stand, their course of action, in world opinion, and thereby you force them to sort of conform to what you want them to do. Delegitimize your opponents. Now, the key characteristics of lawfare is its asymmetric warfare, and often employed by weaker parties against stronger ones. Very obvious. If you are weak, you want to go up against a stronger person, so you use lawfare because that's the tool you can play with. It's non-kinetic, relies on legal processes rather than on physical force. It has an information component intertwined with public relations and narrative control. That's exactly what Dr. Gupta said. So lawfare is intertwined with public relations and narrative control. Lawfare allows you to control the narrative of the war, which, as we know today, the information war, narrative war is as important as the war itself. Now, it has obviously diverse arenas. It occurs in domestic courts, which we see all sorts of international tribunals, as Dr. Gupta specifically spoke about. It's used extensively, whether it be the International Court of Justice or even the International Criminal Court. And the continuous threat of we'll get you before a war crimes tribunal comes from the same use of lawfare and UN bodies. So there's a continuous movement, as you see, back and forth, which continuously goes in UN to define certain issues, to position certain issues, to highlight certain issues, and therefore to interrogate other countries or countries which you are adverse to give them, to make them answerable on those issues. So you first define it, and then you make people answerable to it. For example, you define a treaty, there's a huge dispute of what is terrorism, which is going on, and it's stuck because of definition, because some countries want a very narrower definition of terrorism, which says freedom fighters are not terrorists, and others want a terrorist whenever terrorism happens. So it's obviously that definition helps someone and harms someone, and therefore that is also part of lawfare. Historical context, the use of legal, it has very early roots, so it's not new at all. It has roots which goes to the use of legal arguments in traditional diplomacy and statecraft regarding territory and maritime disputes. Now, an example of this is, I don't know how many of you know of Hugo Grotius, sort of the formulator of international law. He wrote a law on law of the seas. He was put to write that by his state of Netherlands, because they wanted to offset the Spanish claim, who had got one decree out of the Pope, which said half of the world belongs to Spain and the other half of the world belongs to Portugal. So Hugo Grotius was actually sponsored to come out with his doctrine, saying that the law of the seas belonged to everybody in common. So, if you can trace lawfare is being used from that time onwards, almost from the inception of international law. Now, post-World War II is especially the rise of international law, human rights frameworks, and humanitarian law providing new legal instruments. So all your convention of civil and political rights, social economic rights, universal declaration of human rights, and all the politics which arises out of that, of forcing people to conform to that, of forcing states to conform to that, and threatening sanctions based on violation of that arises out of that time. The Cold War, obviously there was limited application of all this because it was primarily an ideological battle. So it was not applied as extensively because everybody wanted to do what they wanted to do. You just have to pigeonhole your arguments in terms of whether you were for freedom or whether you were a socialist or for society. So, but it did make a huge comeback in the post 9/11 era, especially on increased focus on non-state actors, and nations explore non-military levers in asymmetric conflicts. And that is when some of the major legislations in America gets passed. That is when non-state actors become more and more important in pushing your policies. And we've seen that. We can roughly match it onto that. I have a little bit of a different take on it. I think that it also starts from the 1990s itself. Once the balance of power of the world changes and a sort of rule of law regime and international regime is put in place, which highlights certain interests, then the entire game of lawfare just takes off. Because then you can use NGOs, then you can use what was then called, which is not that popular use now, is something called civil society. And word used to be used very often in the 90s, civil society, and use civil society to basically push public policies of certain countries. Modern day recognized component of national security for national security doctrines for many nations and organizations worldwide. So now lawfare is absolutely part of international policy, diplomacy, policies of countries. I was surprised when I was reading onto it. There are defined public policies of China. It's like absolute saying lawfare should be part of public policy. Types of lawfare. One is offensive lawfare, which is initiating legal proceedings to constrain an adversary's actions, sanctions, lawsuits against officials, invoking international conventions. We've seen that happening close to home. I don't want to go into too many details of that. So when you want to push someone on the background, you, number one, threaten sanctions. That is very old in World Trade Organization. When it was World Trade Organization, sanctions before that, under the GATS regime, countervailing sanctions were imposed, threats of sanctions were held out. But what has now happened is a new thing. There were lawsuits against officials. So you want to pressurize a certain country, you get a lawsuit filed. And then you push the country, push the officials, make the persons answerable to courts which are within your own jurisdiction, and therefore, trying to push the issue. This is absolutely new. I don't think this existed too long back. And invoking international conventions. So in lots of, I think first of these major matters was, I don't know whether you remember, I'm sure all of you recall Pinochet, where Pinochet came to visit the former dictator of Chile, I think came to United Kingdom and was arrested, and using an international convention for genocide and things of that sort. So now that is held out quite frequently, that they will curtail officials of a certain country to travel to different countries. Their assets are frozen. Their travel is restricted. Because a few days back, there was this entire question of when I think President Putin was visiting somewhere, there was a threat that, how could you allow that when you're a party and there are orders passed against President Putin? And the same thing with Benjamin Netanyahu, so it is used continuously for that purpose, to threaten, restrict where you can move to. Exploitative lawfare is capitalizing on an adversary's adherence to the rule of law, forcing democratic states to expose sensitive information, creating PR crises. So most countries, especially like us, who like to conform to rule of law, so use that weakness, push those issues in court, getting them to expose sensitive information, which would harm their interests, and also create PR disasters for them, which sort of backs out. This is very majorly used in the Israel and Palestinian dispute, which happens continuously all the time. I was reading somewhere that at one point of time they said we will sort of pass orders from the International Criminal Court against the Israeli administration, and the Israelis were so scared of the PR disaster that would happen that they released a number of Palestinian prisoners. So it's used very actively. And then regulatory lawfare, which shapes international legal norms and regulations to one's advantage. This goes back a long way, but this is part of lawfare itself, influencing treaty negotiations, lobbying for specific interpretations. Terrorism is something, and this happens very often in trade, in international disputes, and things of that sort. Objectives of lawfare: first one, delegitimization, undermining the moral and legal standing of an adversary in legal forums. So you undermine that. Constriction, limiting an adversary's freedom of action because you put legal restrictions, you define the issue in military, economic, and diplomatic spheres. You restrict where his diplomats can go to. You restrict specific people whom you don't want by getting orders passed in different courts. Resource depletion, forcing expenditure of time, money, personal or legal defense, or targeting financial assets. Now, I don't know how many of you know that there was this case in America where Iran was sued in an American court for supporting Libya, for that plane crash in Libya. And as a result, the Iranian government had certain assets which the court threatened to sort of attach. As a result, the Iranians came to a settlement with the parties in America saying that we are willing to settle huge amounts of money. And he said that even if we don't manage to sustain it in the appeal court, but we manage to force Iran to set aside this huge amount of money for settlement, that is good enough for us. Strategic deterrence, discouraging certain actors through the threat of legal repercussions. So when you are scared that you're going to be arrested if you're going to a different country, that constricts what you can act. When you are personally scared, people are personally held liable. It's not only the state which is now held liable, personal people are now held liable. Shaping opinion, it influences domestic and international narratives to gain public support. And normative influence, establishing or changing international legal norms to favor future actions. So once you establish a precedent, then you can use it again and again and again and again. There's a wonderful sort of example, which again, that's available on YouTube on Lawfare, where discussion happens. So an Israeli supporting firm in America uses this technique to take out the Iranians, as I described. And then a Palestinian firm does the same thing to Israeli assets in America. And then obviously then the Israeli firm goes, Israeli backing firm goes to defend it. And the lawyer of the Palestinian firm calls up the partner of that firm who's defending the Straits of Israel and said, we learned it from you. Don't you think is correct? And so, so this goes on. Mechanism tools, so lawfare, judicial forums, so domestic courts, you file it in others' domestic courts, filing lawsuits against foreign states or officials. What is now very prominently used in America, international courts, International Criminal Court, ICJ, and ad hoc tribunals, ICJ, International Court of Justice, ad hoc tribunals like the International Criminal Tribunal for Yugoslavia and Rwanda. You know, when they wanted to solve Serbia, they wanted to solve whoever they want to get in that dispute in the Balkans. They just picked that person as being convicted through the relevant tribunal. Same thing with Rwanda, but it's less in Rwanda and very prominently used very actively in Yugoslavia, in this tribunal Yugoslavia. Non-governmental organization, collecting evidence, lobbying, initiating legal actions, creating public pressure through advocacy campaigns. So, you use non-governmental organizations, spread your message. They can be proxies for your litigation. Happens all the time. We know. I'm in Vivekananda International Foundation, so I don't need to speak about it in great detail. We know that it exists. It's been used for a long period of time. In this country, for a long period of time, we've seen that happening. United Nations bodies, UN Human Rights Council and General Assembly debate, you raise the issue, obviously. Special rapporteurs and fact-finding mission investigating claims. That's why it existed. In various disputed areas, you have these rapporteurs who continuously give opinions which are then used in public domains to constrict the actions of the states which you want to be worked against. Economic and diplomatic tools, sanctions regimes imposing penalties based on legal pretexts. So you have a problem, you impose a sanction. You use personalized sanction. Personalized sanction, you attach what happened in total warfare against Russia. You attach sanctions of industrialists who are supporting the regime, which is unheard of before. But you can do that now. You use the law, treaty interpretation development to advance interest. So this is as old as the hills. You interpret the treaty as to how it suits you. Advantages of lawfare: cost-effective engagement, significantly cheaper than military conflicts, reduces human casualties and physical destruction, requires fewer material resources. So you don't need to spend as much, which is very obvious. Strategic legitimacy provides plausible deniability for those strategic actors. We know this. Whenever you indulge in lawfare, the state is never indulging in it. Some others on behalf of the state is doing it. You can do it domestically in other people's countries. People advocating on your behalf can do it. Mobilizes moral authority through appeals to legal norms, standard, legitimization. This goes to legitimization. Creates perception of acting within established rules, because in the end, again, that perception, legitimization, we are doing everything correctly. Tactical advantage: exploits adversaries that value rule of law and reputation. In a country like us, whose rule of law and reputation is very dear to it, it can be used very extensively and is used very extensively against us. Opens diplomatic and public fronts beyond military engagement, creates asymmetric opportunities for weaker actors. Long-term impact: legal proceedings can have a lasting effect on international norms. So I can change international norms the way I want to forever if I can establish one thing. Shapes future legal framework to favor one's interests. China uses this extensively, litigating to expand its legal interests. Builds foundation for future strategic action. So, you can then work. Disadvantages and risks of lawfare: double-edged, can backfire if one's own actions are scrutinized under the same legal standards and applied to adversaries. So, you can be held to the same standards, and that's a little bit of a problem. Credibility risk: if you overuse this, and legal mechanisms can damage legitimacy and international reputation. If you start doing this over and over again, and people think that you're misusing it, then your credibility to that extent goes down. Unpredictable outcomes: legal processes can be lengthy, complex, and the results highly uncertain as to direct action. As we were discussing with Onuthama, we don't know when the litigation is ever going to end. So, that always happens. So that's the unpredictability. You don't know when the litigation is ever coming to an end. So that's the unpredictability. Lawfare fatigue, which basically says that, people get a little sort of exhausted with lawfare after a point of time if you indulge in something. Ethical considerations. Now, when does the legitimate use of law cross into manipulative use of legal systems? Key ethical questions. Does lawfare turn international law into a mere weapon than a framework of justice? Because we've always thought of law as framework of justice. That's what we grew up on. But is now law also being weaponized? I think like everything in total warfare. Can lawfare be used to suppress dissent under legal guise? I think that's the entire dispute. As to one side says that you're using law to suppress my rights, on the others you're saying that exercise of rights which people are doing are on the other people's behalf. Does aggressive lawfare strengthen or weaken global adherence to legal principles? Because once people know that this is being misused, then you stop adhering to them because you think that you're being taken for a ride. The ethical use of lawfare requires transparency, accountability, and commitment to genuine legal principles. So you should genuinely uphold them rather than merely instrumental of legal systems. So you don't just use them. Now, how do you counter lawfare? One is proactive legal preparedness, developing robust legal teams and doctrines to anticipate challenges, diplomatic engagement, building alliances, and fostering international consensus on legal interpretation. So you have to do that. Strategic communication, countering narratives, and shaping public perception through coordinated messaging. That's extremely important. And norm entrepreneurship, actively participating in the development and interpretation of international law. Now, case studies. So I went into in great detail. One of the most extensive use of case studies is the Israel-Palestine conflict, where extensive use of international legal forums by both sides regarding occupation, settlement, actions in Gaza, including international criminal court investigations. We've seen this, we see it on a day-by-day, back and forth continuously happens. Russia-Ukraine conflict, we saw that as part of total warfare. Multiple legal challenges in International Court of Justice, International Criminal Court, and domestic courts regarding aggression, war crimes, territorial integrity violations. People's, as I said, industrialists close to the regime, their accounts got frozen. They're threatening to sell them and finance parts of the war. You can't be, it was very explicitly used. South China Sea claims, which Dr. Gupta spoke about so much, is China's use of 9-dash line historical against international maritime law, countered by, Philippines got an award to help them in 2016, which favored the Philippines. China doesn't follow it. And it continuously uses this 9-dash line claim to expand its claims. And this is not only as to the South China Sea, this is happening all across. I think we all know we've also at some end of this in many cases. US lawfare applications, counterterrorism and security, Patriot Act frameworks for detention and surveillance. It has international ramifications. We know that it extends the long arm of the law. We've all again seen the Guantanamo legal controversies of foreign terrorists being brought back into US, being tried, taken from anywhere in the world, and therefore being tried in their own country. Drone strikes and legal justification. So they've used drones extensively all over the Middle East. But where does that stand in international law? That's again, you had justifications for that. They've used it as economic sanctions, targeting individuals, entities, and states, financial restrictions against Iran, Russia, North Korea, secondary sanctions against third parties. We've seen that increasingly. So it's not only people who are the states concerned, but anyone who deals with the states. So first the state, then the actors within the state, officials within the state, now industries and companies who deal with the state. They are also getting sanctioned, obviously, for getting them to. Then human rights promotion, using tribunals to pressure foreign government. So use tribunals, which you have, courts in your domestic country to pressurize foreign government for completely other motives, but you use them, sort of use human rights as a guise. Magnitsky Act. Magnitsky Act is this act which says any violation or of human rights in any part of the world can, basically you can invoke American jurisdiction. This is unique, but then everybody, America can, you can do that. So in many ways that's done. Support for civil society and legal aid abroad. We've seen that. I'm not going to go into too much detail. We know what that happens, where that comes from. Cyber operations, legal framework for cyber operation, extraterritorial application of US law, cloud. So means, I don't know, under the Cloud Act, the America can ask for any data stored by any company in the US, wherever the servers are. So, so that's like really extension of lawfare. You're getting information, whatever is stored in servers anyway. Digital evidence collection protocols, lawfare case studies, post. Achha, let's go. Anyway, we can skip this. US lawfare case studies, post 9/11 war on terror, sanctions regimes, civil litigation lawsuits against state sponsors of terrorism, claims under universal jurisdiction principles we were discussing, use of Foreign Sovereign Immunities Act exception. So wherever, diplomats, when they have this exception, you go and catch them. Asset freezing and seizure of legal mechanisms. We've seen that happening. Now, this is something which China's three warfares doctrine. China's people, this is official, China's People Liberation Army officially approved the three warfares doctrine in 2023 as comprehensive approach to non-kinetic conflict. Political warfare, influencing public opinion and international perceptions to create favorable political environment. Media warfare, controlling narratives and disseminating propaganda through global media channels. And three, legal warfare, lawfare, shaping legal context to legitimize China's claim, undermining adversaries' legal positions. So you challenge them continuously, using domestic laws to project power internationally. Exactly what America does. China is doing the same way. I have a detailed sort of presentation which goes on and on about what China is doing, what the US is doing, but we'll skip this because I think we have some sort of a time limit. Claiming the legal high ground in disputes, so it allows them to sort of key avenues of China's legal warfare, asserting historic rights through legal declarations. We know the claims on South China Sea, we know the claims on Arunachal, we know the claims in various parts, wherever China is in conflict, it asserts in Tibet. We know that through historical declaration, 500 years back, 800 years back. Rejecting the 2016 Permanent Court of Arbitration ruling, this is a South China Sea, using UNCLOS ambiguities to justify maritime claims, continuously uses the exceptions of UNCLOS, law of the seas, United Nations law of the seas to expand its sort of claims. On the Taiwan issue, framing cross-strait relations as purely domestic, enacting sovereignty, asserting domestic laws, so that, if you want to invest in Taiwan, we go against sovereign interests of China. Diplomatic isolation through legal pressure. You know that there are less and lesser sort of embassies of Taiwan all over the world because China has said that if you want to do business with us, you have to stop doing. Economic lawfare, trade restrictions under the guise of legal compliance. Conditioning agreements on market economy status, saying that you treat China as a market economy, so we know it is not a market economy. So if you want to trade with us, you have to give us market economy status. Anti-dumping duties and export controls. China uses it very effectively, I think most effectively in any country of the world. Extraterritorial laws. Now, this is where it uses Hong Kong national security law with global reach. So, you can use Hong Kong, which is a great trading center all over the world, and you can use laws from there which can reach across in any part of the world. Foreign relations law targeting critics abroad. We've seen that, so that if you have criticized the regime abroad, you can be targeted, especially if you're Chinese or Chinese origin. Internet sovereignty legal framework. So it claims that you cannot use internet, you cannot, everything. You can't use Twitter, you can't use, I don't know whether you can use WhatsApp, but you definitely cannot use Twitter because, or Facebook or any social media, because there are Chinese equivalents of that. Chinese lawfare, South China Sea strategy, legal countermeasures, Hong Kong, I've gone through this, so I skipped this. This is Pakistani lawfare strategies on Kashmir issue, highlighting human rights violation documentation, challenging India's revocation of Article 370 and 35A, asserting Kashmiri self-determination rights in UN forums, counterterrorism defense, addressing terrorism sponsorship accusations, demonstrating that guideline, the FATF compliance measures, building case against terror financing network. So it continuously protects them. Indus Water Treaty, which Dr. Gupta spoke about, seeing them extensively being used, challenging India's hydroelectric projects, seeking arbitration for the court, where it's got a ruling. We didn't participate, but it's tom-tomming it across the world. Protecting water rights through legal channels. So it uses legal channels to protect those water rights. Sovereignty protection, defending prosecution rights under Pakistani law. We've seen that continuously happening. Whenever we go for terrorists, they say, yes, we're prosecuting them, we prosecute them under our country's laws. Countering sovereignty undermining narratives. So whenever you say that most of terrorism in the world originates in Pakistan, you say, no, this is my legal right, this is international law, so you cannot prosecute me under it. Building legal barriers against external interference. So you continuously ensure that no one can interfere there because you pass laws to that effect that no one who's designated as a terrorist anywhere over the world cannot be accessed because you've created these legal barriers. Pakistani lawfare approaches international forum engagement, active presentation of cases before ICJ, Permanent Court of Arbitration, other international judicial bodies. It has Pakistan has a very unique sort of a large network of international lawyers, much more than we do. You know, anyone would tell you that some of the best sort of international lawyers on these issues are of Pakistani origin. And in fact, at times we've also used them, which has led to controversy, if I recall. So it does have quite an extensive, and we don't have that. Hari Salve we got for Kulbhushan Yadav, but Hari Salve is actually a civil and constitutional lawyer, very eminent, but not actually an international human rights lawyer or anything, or international lawyer. Convention leveraging, a strategic utilization of international and regional terrorism conventions to build legal cases and justifications. Gathering and publicizing evidence to shape global narratives and strengthen Pakistan's legal standing, investing in legal experts skilled in international systems to effectively counter adversaries. So, you know, we need to do that, you know, something which Pakistan does quite effectively. And we also need to have an international global community. And however eminent, and Mr. Salve is one of the most eminent lawyers in this country and a great lawyer, and he's done great service to the country in Kulbhushan Yadav. But we need more people. We need younger people. We need people working on this on a full-time basis. Case studies, the Indus Water Treaties dispute. You know, you saw the lawfare in action. Pakistan initiated arbitration proceedings in the Permanent Court of Arbitration in The Hague. Challenge India's dam construction as violation of treaty provisions, and secure jurisdictional ruling despite India's objections and unilateral suspension attempts. So, you know, demonstrate Pakistan's strategy to use legal channels and highlights lawfare's efficacy. So the fact is they've used lawfare quite extensively in the Indus Water Treaties dispute. India's current lawfare landscape, existing engagements, ICJ intervention in cases like Kulbhushan Yadav, digital strikes banning apps, which we did on economic lawfare, counterterrorism legal frameworks in international forums, and territorial dispute documentation and legal positioning. Counterterrorism legal frameworks in international forums, you know that we are continuously accused of our counterterrorism legal laws being violative of international acts, and we're trying to suppress dissent all the time. So, you know, it's also being extensively used, and our officials are targeted, and so on and so forth, whenever we want to exercise our jurisdiction. Key challenges, predominantly, sort of our lawfare is predominantly reactive rather than proactive, lack of integrated national lawfare strategy, limited dedicated expertise and institutional resources, vulnerability to adversarial exploitation by Pakistan and China, domestic lawfare concerns affecting political discourse. That's something which we have to be aware, because it spills into domestic political discourse. Potential chilling effect on civil society and media. So if we go down strictly on lawfare, it clamped down strictly on lawfare, then the challenge is it may affect legal society and media in some way. So some independent, it would have obviously a societal repercussion, which we should be careful of, because we, of course, we also want a free society. There's no question of that. Lawfare has become increasingly sophisticated component of international strategy, leverages legal systems to achieve political military ends. We'll skip this. Core pillars of effective Indian lawfare policy. We need proactive engagement. We need an integrated approach. We need capacity building. Integrated approach means it has to be across various domains. So law, government, diplomacy, and economics, and finance, and everybody has to work together. Trade has to work together. Because we need an integrated approach. We need capacity building, because we don't have that capacity. And we need people with international law proficiency and strategic communication of that. Policy suggestion. This is my suggestions. The first one is provide a guiding framework for India's comprehensive approach to lawfare that aligns with national security interests while maintaining ethical standards. We are, in the end, a free country. And I think as lawyers, as a lawyer, we would like India to be, if there's no question, and being here, we would like India to be a free country. But we have to have a lawfare which keeps that into mind and balances our security interests as well. So we need to do that. Key components, India-specific definition of lawfare tailored to our strategic interest, clearly defined objectives for lawfare employment across domains. So we need to define that. Identification of relevant domestic and international legal instruments. So as part of that, we'll have to figure out which instrument, domestic or legal, international, we can use for what purpose. So that has to be a continuous research of that. And we need ethical guidelines for ensuring adherence to international norms and domestic norms, constitutional norms, and interagency coordination mechanism with defined responsibilities. So we need to do that as well. Strengthening legal expertise and capacity, comprehensive education for legal professionals, diplomats, military personnel, intelligence agencies in international law, cyber law, and strategic litigation. We don't have that, at least not to my knowledge. Dedicated lawfare units, specialized cells within relevant ministries and intelligence agencies which focus on different lawfare domains. Academic partnerships, collaboration with universities and think tanks to promote research, education, and policy development in lawfare strategies. We need to do this proactively on absolute emergency basis. Policy suggestion number 3, proactive use of international legal forums. How do you go about that? You identify opportunities and legal proceedings, target terror financing and human rights violations, develop robust evidence collection mechanisms. You do that. UN body, treaties, you use treaties. I'm going to skip it and go fast. Expert legal and illegal interventions. You sort of ensure that amicus curiae briefs, which is friends of the court, amicus curiae briefs in relevant cases. So in international cases where you think it's relevant, ensure people who sort of speak for your interests get to intervene in that. Provide expert testimony where you require some people you want. America uses that very frequently. Ensure that someone speaking about your point of view can intervene in those cases going on, intervene in those tribunals going on, and file a case which sort of twists the law to your benefit in subsequent matters. Develop scholarly work supporting India's position. So you get a lot of people, academics, to support your positions on basis of international law. Policy suggestion 4, enhancing digital and cyber lawfare capabilities, develop specialized, on data privacy, intellectual property, and so on and so forth. Digital strikes framework create transparent and legally robust mechanisms for actions like app bans or digital services. We know because that's being used against us. International norm development, actively shape emerging norms, because we have to be proactive and shape norms so that it ensures and protects us, our security, our society, and so on and so forth. Now, we also have to, as a countermeasure against disinformation, legal mechanisms to identify, counter, and build resilience against hostile propaganda and foreign disinformation campaigns. Policy suggestion 5, countering adverse lawfare and domestic space, early warning systems. Now, this is, I think, important, something which will sort of interest us. Develop mechanisms to identify potential lawfare attacks. Monitor international legal developments affecting India. Anticipate adversarial strategies through intelligence. Legal defense teams. Establish dedicated units to counter frivolous lawsuits, which are being used for lawfare. Respond to politically motivated legal charges, as in internationally political as part of lawfare. Coordinate between government departments for unified defense. Domestic legal safeguards. Review laws vulnerable to misuse for lawfare purposes. Reform administrative detention provisions so that we know. Address concerns about basically suits silencing critics. So we'll have to do that. Civil society protection, ensure legitimate activism remains protected. That's in our interest. Maintain press freedom from lawfare intimidation. We have to do that. Balance security needs with democratic values. So how to keep a society free and protect our interests, that should be our primary way. Policy suggestion 6 is clear strategic communication, narrative building, articulate India's legal positions clearly, engage in public diplomacy, use the media, and collaborate with think tanks. I'll put this up for everybody's use so you can use it at a later point of time. Implementation roadmap, form high-level task force, assemble experts on law, diplomacy, defense, intelligence to guide lawfare policy development, conduct comprehensive audit, assess existing legal capabilities, vulnerabilities, opportunities in the international arena, draft a policy document. That's what I've been speaking about, and I'm sure I'm here, so I'm sure hopefully someone will take a notice of what I'm saying, is create a national lawfare policy, incorporating suggested pillars and strategic approaches to do that. Allocate resources, obviously nothing happens otherwise. Establish training programs, create specialized academies and courses for lawfare education and professional development. Foster international collaboration, engage with like-minded nations, coordinated lawfare strategies, information sharing. This happens extensively. This happens all over the world, happens extensively, Israel uses this extensively. America obviously also uses that. We know some of it sometimes, implement regular review, continuously assess and update the policy based on evolving threats and opportunities. This comes to the end of it. So what are the foundational references? Foundational works are, as I quoted, Charles Dunlap's famous Law and Military Operations, Some Thoughts on Lawfare, Harvard National Security Journal in 2001, Andrew Cochrane's Lawfare, A New Kind of War, and this again is the book which is very much available in public domain. Anyone who wants to, please pick it up. Lawfare, Law as a Weapon of War. And there's a YouTube video where Mr. Kitri, there is this wonderful discussion on lawfare on YouTube and on various different perspectives. Some of the Israeli sort of players in America who support Israel, they are on the panel discussing this. There are also issues concerning China, which is being discussed. So that's wonderful, wonderful YouTube. The recent sort of scholarships, I've listed some of them. I'm sure there are many, many more. And I can myself see there are 4 or 5 of them which I don't see as part of the list, but then there's so much I can only fit into this slide. Thank you very much.
So thank you, Mr. Banerjee, for elaborating in detail about what lawfare is and how we should go about developing a national policy on this. I think this is a much needed thing. I think you articulated it so well and so clearly. And the suggestions that you made are all excellent. The question is who will do it and how do we go about doing it? Because this is really now the need of the hour. Because it was interesting to see you mentioning that Pakistan is far ahead in this.
Yeah.
I didn't know. I mean that they have a much.
But there are a lot of lawyers of Pakistani origin lawyers who are involved.
But our Indian origin people are many more than Pakistanis. But where is our? So this is the problem. I mean, you go to any Patiala House Court, 30,000 court, you saw only lawyers. I mean, the sea of black. But how many of you doing this kind of work? They are looking for what kind of briefs? I do not know. They might as well be doing this. I mean, in fact, probably in politics, how many lawyers are there in our country? They ought to be looking at this. For political parties, I think it's a very good subject to take. Now the question is, how do we go about doing it? I think that is where we can discuss. But it's been wonderful presentation, very useful and very clear. We should probably bring out a policy paper on this and send these recommendations. So I just open this now for any discussions and yeah, please.
Myself, Dr. Pravesh Khanna, advocate. How do you see regarding the